Hello, everyone. Good morning. Thank you for being here, and I hope you guys are having a good morning thus far. My name is Brian DeMar. Um, I am a program and policy analyst for the state of Wisconsin, and just wanted to give you a little presentation here about um, some information related to employers and child support agencies, child support orders, and the process as it relates to that. Just a little background of myself. I have been in this role now for a little over a year. Prior to this, I had worked at a local child support agency in Superior, Wisconsin, for 6 years doing case management, things like establishing orders, enforcing orders, um, sending income withholding orders to employers, that sort of thing. And in that time, I've gathered some information and compiled it in a presentation here. I just wanted to talk to you guys about this information. And if you guys have any questions, feel free to write them in the chat. Otherwise, if you wanted to wait till the end of the presentation as well, that's completely fine. But absolutely, if you have any questions, feel free. Okay. So as I said, the presentation is Employer's Guide to Child Support. Starting off, I just wanted to offer a thanks to all you employers out there who participate in this process, whether it's through paper income withholding orders, electronic income withholding orders, um, you know, uh, something as small as the national new hire reporting, and working with your employees on things related to child support, other things that you do on a day-to-day basis as it relates to those. So big thank you to everything you do in that regard. Um, the families, the children, the other parents, the custodians, the kinship providers, everyone involved in this process benefit from the things that you do, and it's monumental. It's very significant. The families rely on these child support payments, and so it impacts a lot of people in a positive way. Some of the things about child support that make it important are, the child support program in itself provides a process for paternity establishment for families that desperately need that particular process to be completed for various reasons, whether it's to enforce their rights, set up a parenting plan, set up some placement with their children, get that process going and settled. Um, and so with that paternity establishment process completed, there's a lot of various rights and availabilities for those parents that otherwise would not have been available to them. So that's important for that particular process. The child support reduces poverty and financial insecurity for children and custodial parents. As I mentioned, the children rely on that funding or that money to kind of bring them out of or it's another thing that helps bring them out of poverty or keep them out of poverty and provide food, provide clothing, access to certain um, extracurricular activities, and so the child support that gets taken out of the other parents' checks and sent to the child support program is available to them through this process. The child support makes up about half of the average income of low-income parents who receive it. There's about 750,000 people that are, essentially lifted out of poverty each year, according to a study from March 2023. Anything more recent than that, I'm sure, would align with that data. The child support program and the child support payments also reduces the strain on public spending or public welfare. because access to child support payments and funds are just, I guess, an alternative or a replacement for having to rely on cash benefits from the state or um, food stamps or food share benefits from the state, that sort of thing. So anytime that we can put money with the families that need it, as opposed to having them rely on assistance from the state, that just is another benefit that they can rely on as well. And then one other thing that not a lot of people think about when it comes to child support is it also increases the involvement and increases the involvement of non-custodial parents in children's lives through the participation in child support payments in the child support program. When the child support is figured out, oftentimes it opens the lines of communication between both parents and the non-custodial parent and the child. Oftentimes they're already talking about child support and the child support payments and how that aspect is playing out. It provides that open avenue for communication in other areas or other ways of their lives, whether it be placement, whether it be extracurricular activities, child well-being, and just provides them that little glimmer of the communicating in other ways or other areas of their lives. So it has a positive impact, not only just financially, but also just the relationship building aspect of that dynamic. So now when it comes to the employer's responsibilities, there are a few things that we do rely on to keep the program running and be successful when it comes to collecting the payments. One of the things that we find extremely helpful is the new hire reporting that is done when it comes to providing data on the parent that we're seeking to enforce the order against and ultimately collect the payments from. So that means once you've hired a individual and we're looking for that individual in some way, maybe to collect for child support or to set up a collection because of the health insurance that we're hoping to have the child covered under through the employment. The new hire reporting ultimately is helpful in those two aspects. As I stated, the medical support obligation, maybe the new hire that you've brought on is eligible for health insurance benefits through the employment, and we would want to have the child covered under that health insurance. We would, at a later time, discern or determine whether that health insurance would need to be enrolled for that employee, and then the employer would be very important in that particular process as well. And then income withholding, starting the income withholding process to collect the payments and send that to the child and the other family. And then one other thing that's helpful is when the employee, or if and when the employee leaves that employment, the timely notification of that termination so that we can update our records on our side and then stop the income withholding order so that it would prevent any erroneous payments or any kind of inconvenience for that particular individual as it comes to their income or any sort of financial hiccups that come with the income withholding order. So new hire reporting. A new hire is often defined as hired for either the first time or rehired after more than 60 days absence. So if you've just brought on somebody for the very first time, they've never been employed by your company, you would hire, or you would report that person as a new hire in the new hire process, and then they would come through in our system that we have. There would be a notification for the case manager to take certain actions as a result of that information. So that information that you've reported as a new hire, um, that's essential for getting out any sort of income withholding orders, or determining what the income of that individual is through the employment, so that we can either establish a child support order or establish a health insurance order as well. So that information is extremely helpful. And then if they've been absent for more than 60 days from your employment, hiring them back as a rehire is considered a new hire as well. There are various formats that you can utilize to make a new hire reporting. You can either use the internet reporting through the DWD website, www.dwd.wisconsin.gov/UINH. That's one area that you can go to make that new hire reporting. There's also electronic reporting and then paper reporting by faxing the documents to the fax number on the screen. Whatever is preferable is completely fine. It all goes to the same place, and it's all greatly appreciated as well. There's a contact number on the screen for the Wisconsin New Hire Reporting Center. If that's the route that you would take for information or the new hire process. And then there's a multi-state employer option available for that as well. So there's various formats to make that information available. How often do you report new hires? Well, technically, employers must report within 20 days of an employee's hire date. If the hire date becomes delayed in any way, it I guess would really depend on what the circumstances surrounding that situation are. But technically the 20 days of the new hire's employer date, the employee's hire date, is what the new hire date reporting is supposed to go towards. So do your best, I guess, to check in with your legal representatives on that particular aspect or those requirements. But employers who submit reports magnetically or electronically shall submit the reports in 2 monthly transmissions, not more than 12 to 16 days apart. If there is no need to report if there are no new hires since the last report. So it's just saving you time and paperwork at that point. But timely submissions to the new hire reporting can only help both the child support agencies and, I'm sure, the employers themselves. What if you have never reported? Well, begin by reporting any new employers that you have hired within the last 180 days, if you're just reporting for the very first time. That covers, the last 6 months or so, and would be comprehensive enough for the child support agency to utilize that information going forward. Continue by reporting any new hires that you have had within the 20 days of their hire date. So at that point, you'll just be reporting within that 20-day period going forward. So when it comes to health insurance, you have some terms that the health insurance order will contain within it and are helpful to mention here. The dependents are the children most often, and they must be enrolled in a family insurance plan without regard to seasonal restrictions. So open enrollments, usually it's the time period between October and whenever the open enrollment period for your employer, for your company is. And then they may not be denied coverage on the grounds that the parents were never married, the dependent is not claimed on the employee's federal income tax return, or that the dependent does not reside with the employee in their insurer's service area. So they're basically, when you received a um, health insurance order, the uh, national medical support notice from a child support agency, the requirements are to assess the health insurance that's available to that employee at a reasonable cost, and then this health insurance order that you've received from the child support agency is a special exception to be able to enroll that employee in that health insurance that's available to them outside of the open enrollment period, so that you don't have to wait for that time period to come before enrolling that employee in that health insurance available to them. The employee may not eliminate the coverage of the dependent once they're enrolled in the plan, unless the employee provides written proof that the order that you've received from the child support agency is no longer in effect, or that the dependent is enrolled in a comparable health insurance plan elsewhere. So the employee has the obligation from the court to have the child enrolled in that health insurance plan. What the child support agency is doing is they're providing you notification through an order to enroll that employee in health insurance available through the employment. And so if the employee comes to you and says they don't want to have the health insurance anymore, essentially they have no say in the obligation or the enrollment, unless they're able to prove that the order is no longer valid, or they've already provided other alternative health insurance, and they can provide that information as well. I think the best course would be to check with the child support agency to make sure that any sort of information you get from the non-custodial parent or the employee complies with your obligation to follow through with the health insurance order that you received from them. So this is just a copy of the National Medical Support Notice that you'll have received from the Child Support Agency. There's essentially 4 documents within the complete packet, you can call it, that you'll receive from them. There's a Part A that contains 2 documents, and then Part B that contains 2 documents as well. So it'll contain, your company name, the employee's name, identifying information for the employee, and then on this first sheet here, this will be the front page. On the bottom there, right before the block of wording, there's some check boxes, and on that particular section, you'll indicate the health insurance that is available through your employment. And so you'll indicate those available health insurance plans that are accessible to the employee. And then there will be some other pages behind that you'll fill out some additional information. One of the pages that is available is an employer response. That one, you'll fill out the information that is applicable to the employment plan, the health insurance plan available to the employee. And then you'll return that to the child support agency, who will then use that information to enter it into their system and assist them with the case management as it relates to the health insurance order obligation for the employee. So it's very important for you to fill out the packet of information as complete and accurate, and especially important for you to fill out that employer response and send it back to the child support agency. In addition to that, the plan administrator's response is similar in that is an information that you would send back to the child support agency as well. Okay, so this is just an example of the section that I had mentioned on the first page, where you would indicate the health coverage is available to the employee. So that if it's a medical plan or a dental plan or a vision plan through their employment that they've been identified as having access to at a reasonable cost through their employment, then you would indicate that on this form here in this section, and then proceed forward with filling out the rest of the documents. So just wanted to touch on reasonable cost a bit as it relates to health insurance plans. According to DCF, Wisconsin statute DCF 150.05 1B2, the definition of reasonable cost includes a provision that the reasonable cost is defined within 10% of the parent's gross monthly income. So if you've made a determination of what that employee's gross income is, monthly gross income, just take 10% of that, whatever that number is, through their employment, and then that is the reasonable cost standard of the health insurance obligation. So if the person makes let's say $100 a month, and you found out that 10% of $100 is $10. So if the insurance plan that you offer to that employee costs them $10 a month, then that insurance plan would be within 10% of their gross income, and would ultimately be determined that they have access to that insurance plan at a reasonable cost, and should then be enrolled in that plan as it relates to the health insurance order that you receive from the child support agency. If there are any questions as it relates to health insurance and the reasonable cost standard, please feel free to reach out to the child support agency for those health insurance questions. Now, that reasonable cost standard applies to the full cost of the policy rather than the incremental cost of just adding that child. So let's say the employee is already enrolled in a health insurance plan through your employment or through their employment prior to you receiving that health insurance order, and you are determining the cost to add that child to the plan. Well, the reasonable cost standard applies to the full cost of the policy to the employee, for that employee and the child, and not just the cost to add the child to an already established health insurance plan that the employee is enrolled under. Okay, some information. Just it's been effective since July 1st, 2018, and it's updated on Part A of the employer response form. Now, the termination of health insurance, what is satisfactory written evidence that my employee is not required to provide health insurance? So when let's say the employee comes to your HR or whoever is in charge of health insurance plans, and says that they no longer need to be enrolled in the health insurance for whatever reason, you're going to want to have them provide some sort of proof or information to support that, and not just take their word for it and terminate that health insurance through the employment. When you receive for the employee a new order or a notice to withhold income for child support with the health insurance box not filled in, by not checking that box, the child support agency is indicating that the employee is not court ordered to provide health insurance coverage for their dependent child. So something to that effect will be what you would want to rely on for information related to termination of the health insurance plan for that employee. You receive a letter from the child support agency stating that the identified employee's medical support order has been officially ended, and/or the employee is no longer obligated to provide health insurance coverage through their employer. So there's another avenue when it comes to termination of the health insurance health insurance plan for the employee. If you've received a letter from the child support agency indicating that the employee no longer needs to be covered on the health insurance plan, at that point, then you can safely terminate that employee from the health insurance plan that they're enrolled in. And then a parent provides written documentation from an insurance carrier that the children have comparable health insurance coverage and that coverage is currently in effect. You or the plan administrator must notify the issuing agency prior to ending coverage for the child. That goes to the employee being enrolled in alternative health insurance through a different avenue or means. And then at that point, you can utilize that information to terminate the health insurance for that employee as well. Just wanted to provide some data as it relates to income withholding collections to kind of highlight the importance of this funding or this money for the families that receive it and use it. So in the in the fiscal year of 2024, the child support program collected $29.5 billion in child support. 74% of child support was collected by income withholding from an employee's paycheck, and 97% of child support collected went to families. The child support program served 12.2 million children, 1 in 6 children in the US. So it impacts a great amount of people and benefits them positively in their lives. Now, changing course to income withholding. Wisconsin Statute 767.75 address the income withholding obligations as it relates to child support agencies. And it provides some definitions on income withholding for the employees, the employers, and the child support agencies to rely on. There is a notification to employers to withhold that's sent out either by paper or electronically. And the employers have cost charges for income withholding that they need to assess and either apply to the employee or if not, then that's something that's up to the employer as well. And then there are withholding limits and amounts that are discussed through the CCPA as it relates to the amounts that can be withheld from the disposable income of the employee. R&D withholding is applicable as well for child support cases and may be withheld from the employee's income at a certain time of the year. When to start withholding? Well, no later than the first pay period that occurs within 5 workdays of the date on the income withholding notice. So once you receive the income withholding notice from the child support agency, you are expected to start that no later than the first pay period occurring within 5 workdays of the date. When to send the income withheld funds? Within 5 days of that withholding. So essentially as soon as possible, but the guidance is within 5 days. And then when to stop that income withholding when you've received notification. Income withholding orders remain in effect until further notice or employee termination. So if you've terminated the employee, you can stop that withholding and then you'll report that termination through the National New Hire. So then the child support agencies will, be able to make the adjustments on their cases on their side. But one thing that you could do as well is you could, notify the employer if you have lines of communication with that individual or that worker. But oftentimes, the hope is as well that the employee will notify their caseworker, and then the caseworker could make adjustments as needed on their side as well. And oftentimes when the caseworker is notified by the employee, the terminated employee, they'll send you a termination notice of the income withholding. So then you can have that for your records as well. Just a snapshot of the income withholding order, the front page. This information here is what will indicate to you the amounts that should be withheld from the employee's pay, whether it be through weekly pay, biweekly pay, monthly pay, however you, as the employer, pay out the employee's pay. The order itself will indicate how much that withholding should be in relation to that time period or that frequency. So the first section up there with the blank per blank current child support, that will lay out the order obligations of that employee. And then underneath that, amounts to withhold, that's the section that will indicate to you as the employer how much should be withheld from each pay period, depending on the frequency. So a little bit about the CCPA, the credit withholding limits. The CCPA limits are 50% of disposable income if the payer has a second family and does not owe child support. 55% of disposable income if the payer has a second family and owes past due support. 60% of disposable income if the payer does not have a second family and does not owe child support. And then 65% of disposable income if the payer does not have a second family and owes child support. What that applies to is if the amount that can be withheld is not sufficient to satisfy the order, or if you can't withhold the amount that's stated on the front page, that slide that we were just on, which showed the amount that you're supposed to withhold based on your frequency. If you can't withhold the amount sufficient for that particular number, there's a percentage that you can withhold that can comply with the limits on the withholding amounts, and these percentages are what you should rely on for those particular situations. And then just to further define, a second family is a spouse and or a child living with that particular employee. A little bit else, a little bit more for the Consumer Credit Protection Act, or the CCPA. This is the spot within the withholding order that information will be stated to you as the employer for you to see, and it's on the second page of the withholding notice, so it'll be just behind the first page with the amounts that indicate how much you should withhold. So there'll be a percentage right in the middle. If you see the percentage, that will be what tells you the percentage to withhold from their disposable income in those situations. When it comes to income withholding, there are priorities with relation to how much money is going to what debts that the employee owes. So just to give you an idea of how it works as it relates to the payments that you send in. So the disposable income equals the gross income minus taxes, Social Security, Medicare withholding, but not retirement or medical savings accounts. So that's what the disposable income means for you as the employer when you're trying to determine what disposable income percentage to utilize. And then withholding priorities, we have a hierarchy of how the payments are applied. And so at the top of the list, the current support obligations that the employee has are number one. Number two, the current spousal support, any sort of spousal support that the employee is obligated to pay. That's second on the list. And then it goes medical support, past due support, past due spousal support, receipt and disbursement fees, and so on and so forth. So the payments that you send in will be applied in that way. There are some child support calculators that are available to you through the website that you can use to determine how or what the withholding should be in certain situations, certain unique situations. So if you have two orders from two different states, and you're not sure of how to withhold the funds or the pay to satisfy both orders, there's a calculator for that, and that will help you to figure that amount out or those amounts out. If there's a support order and an R&D fee order that you've received, and you want to know how much withholding you should do for each of those two orders, or to satisfy those two orders, which one should take precedence or priority, you can look back at the priority for withholding and then determine that information as well. Or there's a calculator to help you in that situation. If you have a support obligation order and a health insurance order, and you want to know, again, how much to withhold for each order, there's a calculator for that. And there is some information on the website, the DCF public website, that will help in making those determinations, or just kind of answering any questions that you may have for those situations when they pop up. Just a little snapshot of what the calculators look like for those situations, just so you can have an idea of what you'll be dealing with when you ultimately decide to utilize those calculators. So there is an income withholding fee that is able to be assessed by the employers to the employees for the withholding process. The fee is lesser of $3 or the actual cost of withholding, if that amount is determinable. You can assess that amount from the employee's pay, and not send that amount. One fee per pay period, unless there are separate withholding orders from two states, or separate regular withholding and receipt and disbursement orders. Fees are deducted from the employee's wages, not from the amount withheld for the support or the R&D fee. So it has to be separate from the amount that you've withheld from the specific obligation order. And then ultimately you'll keep that money to recoup you for the withholding process and not have to take it out of your own expenses or what have you. So the income withholding R&D, what are R&Ds? Are disbursement, receipt and disbursement fees. The section, the applicable section within the Wisconsin statute states that that it allows for the collection of R&D fees through the use of withholding. So it's basically a fee that is assessed to the employee by the child support agency for case management, generally speaking, and so it's assessed yearly to the employee, and then collected through either child support payments by the employee or through the income withholding process. There are two notices that are sent to the employers. The income withholding order notice, in the income withholding order notice, the employer will be instructed to deduct up to $65 for the R&D fee for each court case where the employee owes at least $35. So there will be an IW-27 that's sent out to you, I think it's 3 times a year, and you'll receive that order, and then it'll instruct you to deduct up to $65 for that particular fee, and it's separate from the child support order that you've already you may have already received from the child support agency. So it's important not to get those two separate orders confused. The R&D fees, as I said, must be remitted separately, and there's no electronic funds transfer that's available for that particular fee. Maximum that can be withheld per pay period is $195, and the employee gets an informational notice related to that particular fee. The withholding notice will be sent directly to you, and then, as I stated, it's sent 3 times a year. It's staggered, so it's I think September, March or April, and then there's another one in about June or so that you'll receive. So it's about 3 times staggered throughout the year that you'll receive that separate and distinct R&D fee notice order. There's some other issues that are related to income withholding that are important to mention. Income withholding order notices from other states. With regard to mailing payments to other states, that is a separate and distinct process and would need to be, discussed with those other states, and you would need to identify the policies and laws distinct to those other states with regard to, the limits or the priorities or the processes when it comes to sending those payments. The support payment processing, as it relates to the employer withholding list or the coupons, there are payment methods available, and when it comes to sending in the payments, there are various methods or ways that you can send that payment or payments. One of them being the coupon that you can utilize to send those payments to the trust fund, to have that payment applied to the case for the employee. And then any status changes that you would need to indicate to the child support agency, you can indicate utilizing a coupon for that particular employee as well. Remitting payments for that employee to the trust fund to have that applied to their case. Employees do have a legal obligation to withhold and remit payments. And if there are issues or delays or outright refusals, which I don't know that there's been a lot of situations of that, but most common being employee starts working at an employer doesn't withhold within a certain time period, and then child support agency contacts the employee or the employer, and then there's a discussion had. Ultimately, it's relayed to the employer that they could possibly be found in contempt if they don't fulfill the child support order or the notice to withhold and send the payments. So a court could find the employer in contempt for not obeying the withholding notice and remitting and withholding the payments. And then, like I said, there are some ways to pay for the child support order that you receive or the notice to withhold. You could either send a payment through the mail to the trust fund. There will be an address on the income withholding order that you receive, either by paper or electronically, sending the payments. Or you could pay through a website. It's called Expert Pay. You could set up your employer or your company to have the payments sent on that website if that's a better alternative for you. There's a electronic withholding order process or a way for you to send payments electronically, receive the order electronically, and then respond to that electronic order that you receive. The electronic income withholding order is a streamlined, efficient, and cost-effective way to process child support income withholding orders. And there is no cost to the employer, so it's just a more efficient way for child support agencies to send the income withholding order to the employer, and then the employer can respond to that income withholding order that they received from the child support agencies. And then that way there's no paper involved. Oftentimes it's quicker because it's an overnight process, and you wouldn't have to wait for the mail or any sort of issues related to that. It's a nationwide program administered by the Federal Office of Child Support Enforcement. It actually, the Office of Child Support Services is now called the Office of Child Support Enforcement. So that's my apologies on that typo. All states, including Wisconsin, use EIWO, so it's available through all states that you may receive a child support order or income withholding order from by paper now. So if that's something that you want to switch over to, the process is easy, and like I said, it's only beneficial to you in that it doesn't cost you anything and it saves on paper. Participation is optional, but may be federally required in the future. It's with a lot of things, there is a shift towards going digital or going away from using paper more often. Now, how does EIW work? The state electronically sends the income withholding order to you as the employer, and then you can send an electronic acknowledgement back to the state, indicating that you've received it and that you'll start to send the payments in. Or you can indicate that the employee has been terminated, or any sort of changes in the employee's status, and then that will ultimately indicate whether the income withholding will be applied or followed. What's the rationale for using EIWO? Well, the EIWO takes the paper and postage out of processing child support income withholding orders for employees. There's no need to handle mail and track paper copies. Like I said, it's more efficient and oftentimes quicker process for getting the support order to you as the employer, and then eventually getting the payment started sooner rather than later as well. So it's something that if you aren't already doing EIWO, it's definitely worth looking into. The EIWO system allows employers to seamlessly receive and process electronic versions of orders, easily transmit acknowledgements to the correct child support agency, safely and securely share information about employee changes, handle fewer phone calls from child support agencies and parents. Just wanted to further highlight some benefits to you as the employer as it relates to EIWO. It, like I said, it improves efficiency. It saves time with electronic workflows instead of manual paper processing. It's system to system, so it's takes the people power out of it. There's still a worker that has to monitor that particular aspect of your side and our side as well. But human entering errors are mitigated or prevented from utilizing this process. Lower costs. It doesn't cost anything to you to utilize EIWO. It's just a system change. Save money by reducing the need to receive and mail hard copies of orders. Avoid expensive rework when orders are sent incorrectly. It also it could increase productivity. There's less time for payroll staff to set up and manage income withholding orders. Less need for employees to resolve their income withholding issues in person during business hours. So that order will be updated by the child support agency through the system, and then your system will receive that update, and then you'll be able to terminate the withholding or update the amount. If the frequency gets changed, that information will be updated as well. So there'll be less time spent on the withholding process as it relates to the order for employees of HR or similar positions. It could also enhance employee satisfaction. Employees who receive child support can get paid faster through this process. If the withholding order is set up sooner, the withholding itself can be completed sooner as well, and then the payments can be received by the people who rely on those payments. Employees who pay child support can avoid frustrations caused by late payments, such as interest charges or notices of failure to comply. And that goes back to the the contempt that can possibly happen to the employer. There will be some notices that are sent to the employer for failure to comply, and then notified of the possibility of contempt. Those notices themselves could be prevented by this enrolling in this process, because the process is electronic. It's not something that can be interrupted by delays and mailing paper notices or entering information incorrectly, that sort of thing. And then you can gain a competitive HR advantage, differentiate your organization as an employer of choice by making child support income withholding order payment and compliance easier. So less stress on people that are involved in this process, whether it's the HR individuals, the employee themselves, or managers of your company. It's not something that would need to be worried about or troubleshooted. If I said that correctly, I apologize. It's just something that hopefully the intent is that it will be kind of a more streamlined version of what was already occurring. And there was some issues that were identified with the paper process. So this EIWO is a hopeful fix to that. So there are some implementation options when it comes to EIWO. They're based on the size of the employer's workforce and IT capabilities. And option number one is the system-to-system interface. It's recommended for medium to large employers with IT programming resources available. So there's some system changes that would need to be done for the option number one. The implementation time for this is 3 to 5 months. Option number two, there's no programming, recommended for smaller employers who receive a few withholding orders each month and do not have IT programming resources available. Implementation time is shorter, 2 to 4 weeks. And then option number three, EIWO Online. It just came into effect January of 2024. It's recommended for smaller employers who do not have an internal IT server available. So it's an online option that can be utilized for the EIWO. Implementation time for that is much shorter, at 5 to 15 business days. So whatever works for your particular company, there's probably an option for you, and can be explored. How to get started in EIWO? You sign up for EIWO through the Office of Child Support Enforcement, OCSE. The Federal Office of Child Support Enforcement website can be found there. And then there's some questions that can be sent to the employer portal at acf.hhs.gov. So if you have any questions related to that process, there's some information within their website, but then you could also email them with questions that you may have that aren't covered through the website. This is what the child support portal will look like for you when you utilize the EIWO process where you signed up for EIWO. A few key contacts that you can utilize for information that we've talked about today. For the new hire reporting, you can contact them over at DWD. There's a withholding list or a coupon that you can utilize through the trust fund. There's a phone number there, hours of operation. There's also an electronic funds transfer that you can look into if you want to use that for paying the child support obligations. Excuse me. And then, like I said, there's calculating the amount withhold. You can contact the county / tribal child support agency that issued the notice, or you can utilize the calculators within the DCF website. And then if you have questions on R&D fees, you can contact the R&D specific line at that phone number there for questions related to that particular payment. And then just some general information on DCF. There's a website here, a lot of helpful information related to, employer responsibilities. If you have questions just related to the child support program, there's a lot of information on the website. And then, if you have documents you want to fax DCF, there's the fax number, and then email for any queries you have related to the program, withholding, anything you may have. There's the email address that you can send those questions to. Again, the Office of Child Support Enforcement, it's not service. I apologize for that again. There's some information here for, if you want to contact them through the phone, if you want to contact them through the email address here, or if you want to go on their website and just kind of peruse their information. There's a lot of information for employers that they have that cover areas that you may have questions on. I would recommend looking at it if you have questions on withholding or questions just generally speaking on the child support program. All right, I did say a lot of information there, so if you do have any questions, I can see if there's any in the chat here. But otherwise, just feel free to let me know if you have any questions at all.
Thank you, Brian. Any questions that you do have for Brian, feel free to share them in the chat.
Would you like me to start now, Dom, or do you want to give people a little break?
Maybe we could do a 5-minute break and then we'll have you get started, Kathy.
Okay, sounds perfect. times? No, I can't remember.
Kathy, ready whenever you are.
Okay, I am ready. So good morning and welcome. We used to call this the Labor Law Clinic, and then I think it went to Friday Fundamentals, and now I'm not sure what we call it because today isn't Friday, although I got up thinking it was, so that's on me at this point. My name is Kathy Lake. I am an administrative law judge with workers' compensation. I have been practicing in the area of workers' compensation. I figured it out in the car this morning, about 37 years. And I've been an administrative law judge with the Workers' Compensation Division for 27 years. I've been with the state for 28 years, all told. So I've been here more than a minute, although sometimes it feels like a minute, really. So we are going to talk this morning about workers' compensation law here in Wisconsin, and it's also referred to as Chapter 102 of the Wisconsin statutes. Sometimes we refer to it as the Act, and some people just say workers' comp. So there's various names for it, I suppose, or monikers or handles that we use for it. But in the end, it is the Wisconsin workers' compensation law. One of the most unique things about our particular act is that it was deemed to be constitutional by the United States Supreme Court on May 3rd of 1911. So we've been running strong for almost 115 years at this point. And our workers' compensation law is a fairly basic law. It doesn't change a lot from year to year or from administration to administration because we have an entity referred to or called the Workers' Compensation Advisory Council. And that is a group of 5 representatives from labor, 5 representatives from management, and 3 representatives who are non-voting members from the insurance industry. This group decides when law changes should be made with respect to the act, and then they bring those forward in what we call an agreed upon bill. The agreed upon bill is then taken over to the legislature, who holds hearings on it. And then if it is agreed to by both houses of the legislature here in Wisconsin, it's the Senate and the Assembly, then the bill is moved on to the governor's office for signature. And interestingly enough, the Senate is acting on the most recent agreed upon bill today. It's already passed the Assembly. And if the Senate passes it, then it will move on to the governor's office for signature and implementation. So those are a couple fun facts that aren't in my PowerPoint, which is just fine. So today, what we are going to talk about is what is workers' compensation, the requirements that employers need to have. We'll talk about what constitutes injuries. We'll talk about what you as the employer should do after you have been given notice of an injury by the employee. What benefits are payable. We have some special types of claims that also can be made by the injured worker. And then actually there's a couple of claims that, or at least one claim that can be made by the employer or its insurance carrier. And then we'll talk a little bit about what happens at a hearing. So I will be happy to take questions. I don't know if I'm going to be able, I'm not so good with technology. I'll admit that. I need my like Gen Z kids here with me to help me. So I will try to, at the end, go through the chat and we'll go through any questions that you may have. All right, so I basically laid out our agenda for us just a second ago. We want to talk about what is workers' compensation. Well, first of all, workers' compensation exists throughout the United States. And no, there is no federally mandated workers' compensation programs for every single state. The feds do have their own workers' compensation program and their own law, and each state has its own law. Some of them are more robust than others. I would say the one in Wisconsin is very robust and has long stood the test of time. So basically, it is a no-fault insurance policy, which means that it doesn't matter if the employer caused the injury or the employee caused the injury, or basically nobody caused the injury. And we would refer to that, right, as an accident. It wasn't anybody's fault. It's just something that happened. So No fault means that no matter the cause of the injury, the injured worker is going to get benefits if it's deemed to be work related, okay, which is a sum certain. We have temporary total disability, permanent partial disability, medical expenses. Medical expenses, not so much a sum certain, because it used to be here in Wisconsin that 2/3 of the benefits that were paid were for temporary total disability, which is wage loss, and permanent partial disability, which is permanent impairment into the future. And now it is 2/3 of the benefits that are paid are medical expenses. So medical expenses continue to rise here in Wisconsin. If you talk to the medical providers, though, in their lobby, they will tell you that Wisconsin is, I think, second in the nation in getting employees back to work in a, very timely manner, or even maybe before would be expected. So they say that because they have excellent access to excellent health care, I've heard them say this, and that their medical bills are paid in a timely basis, and it is a fair amount of money that is paid, this gets the injured worker back to work more quickly. So you can believe that, you cannot believe that, that's what I'm told. So also, under this no-fault system of insurance, this pays benefits to employees for accidental injuries and occupational injuries. So accidental injuries are just what we talked about a minute ago. It just happened. And, a person slips and falls. That's accidental. A person cuts their finger off, God forbid, but it does happen. That's, again, accidental. Occupational diseases are conditions that build up over time. Somebody that works on the floor of a large manufacturing plant and lifts 60 or 70-pound wheel housings or something like that every day for 40 years. Somebody who worked in a foundry potentially and developed mesothelioma because they were, or silicosis, I should say, because they were exposed to asbestos or sand, silica. Those would be considered occupational diseases, something that happens after usually an extended period of work for an employer in the type of employment that would cause that type of occupational disease. And I know that sounds like a lot of words, and I'm sorry about that, but that is kind of how we clarify it. So an employer's liability is limited in exchange for prompt and certain payment of benefits to the employee. And that is the no fault portion of this. This was struck as what we call the grand bargain here in Wisconsin. The grand bargain was that employers knew about how much they were going to pay, and therefore their insurance carriers knew about how much they were going to pay for given injuries. And the employee in exchange didn't have to go to circuit court and request things like pain and suffering and some type of mental condition, stress, duress, all of those things due to the work injury. Now, many of you, I'm sure, are familiar, at least, there's plenty of shows out there on television that are courtroom based shows. Not so much the criminal stuff, but I'd be talking about the civil stuff here. And we've all seen, I think, people who have gotten very large awards, millions of dollars are awarded to them by a jury or by the judge, and that's because they alleged some type of pain and suffering benefits. Or damages, I should say, not benefits, damages. Damages like that can get in the millions of dollars because the jury or the judge can take into account how the person has suffered as a result of the injury. Workers' compensation does not take into account suffering. It hasn't. I've had to tell many people that over the years at workers' compensation hearings, as well as places like pre-hearing conferences. People come in and say things like, well, I want $1 million in pain and suffering, and I have to get out my statute book and read to them what is covered. They do not appreciate me at that point in time, and I try not to take it personally, but they also need to remember that those types of things are not covered. And as difficult as that may be, it is what it is. So, which types of employers need insurance? So first of all, we have some criteria that is set forth in the statute. One is anyone who employs 3 or more workers. And those workers can be either full or part-time workers. They do not all have to be full-time. And if they are all part-time, if it's still 3 or more, then you still have to have insurance. Then you have employers who have less than 3 employees. You could have 1 or 2 employees, and you pay a combined gross wage of $500 or more in any calendar quarter for the work done in Wisconsin. So if you are hiring somebody to come and, take care of your kids for the summertime, so to speak, well, maybe not that, because that may be household help, so domestic labor. That may be a little bit different. But say you own a business and you have, some kid come after school and he comes 4 days, she comes 4 days a week and she cleans for you. And at the end of a calendar quarter, you have paid this kid $500. Well, now you are an employer subject to the Workers' Compensation Act. So you should reach out to your insurance agent and see what you need to do to procure insurance. Some farmers require insurance, not all, but some do, especially if it's a corporate farm. Some of the family farms don't require them, but we have special rules regarding farmers. And if you have questions about farming and whether it is subject to the Workers' Compensation Act, you can reach out to us here at the department. We have a group that's in our insurance bureau, and they will be able to help you discern whether or not the farmer is an employer which should be subject to the act. And so these are kind of the categories for this. Pretty much everybody's an employer who pays wages. That's kind of what it comes down to. So then we look at the employer must have insurance by the 10th day of the first month of the next calendar quarter. So if you found out that, we go back to my example of the young person, high school student who's coming in and doing some cleaning for you, and you pay wages in January, February, and March of 2026 to this individual, then you need to have workers' compensation insurance in place by the 10th day of April of the next calendar quarter. So you get done with one calendar quarter, and by the 10th day of that next one, you need to have your workers' compensation insurance in place. And if things are a little, skewed, maybe the kid starts for you in March, and then, you pay him in March, April, May, and June. Okay, so we look at this by calendar quarter. Then by July 10th, you would need to have your workers' compensation insurance in place. All right, so let's take a look at employees covered by workers' compensation law. Fun fact, when the workers' compensation law went into effect, it only applied to public employees. It did not apply to private employees. And then eventually it was expanded to include private employers also. Nearly all private and public employees in Wisconsin are covered by the Workers' Compensation Act. We will talk about who is considered to be an employee. So again, our statute is pretty defined, and there is a specific definition of who is an employee. So most workers are employees under the Workers' Compensation Act, but our statute kind of says the following. Every person in the service of another under any contract of hire, express or implied, and it goes on to include family members, with the exception of some farm operations, minor children, part-time employees, and corporate officers. Now, if you were a sole proprietor, you would have to opt into being covered under the Workers' Compensation Act if you choose to get a policy. Corporate officers are immediately included. There are some different rules for members of an LLC, okay? And the LLC, you actually, I believe, if you were a member of the LLC, then you have to opt into the workers' compensation plan. You aren't just automatically included. And one of the things that I've often said to small employers who may not have too many employees, okay, but they also are an owner operator of the business that they own, and they're working full-time too, you might want to think about including yourself in this business as far as being included on the workers' compensation policy. I used to work for an insurance company a number of years ago, and we sold insurance to a lot of small mom and pop businesses in Illinois. And I would often have this conversation with especially daycare providers. They would say to me, well, I really can't afford to include myself. And I would always say to them, do you work full time or part time at this? Well, sure. I step in when any of my employees are gone. I do the books. I help if there's any types of shortages, all of that kind of stuff. And I always ask them, well, who's going to pay you if you go out? If you're not getting any temporary total disability benefits or workers' comp benefits while you're out because you're injured, and then you have to hire somebody new to come in and take your place, while you are out due to a work injury, then you're kind of doubly penalized, right? Because now you're paying out new money to somebody and you have no money coming in for yourself. So a lot of people don't necessarily think that way. And many of them, though, have very good insurance agents who are very knowledgeable. And I'm sure that they are having these hard discussions with their clients because nobody wants to be injured at work. It's not something I think anyone relishes or desires, but sometimes it happens, and especially in a small business where you're kind of the jack of all trades, right? Excuse me. Okay, so let's move on to independent contractors. I'm sure all of you have seen in the news that there are various entities who would like to have their employees or people that they hire to work for them all be independent contractors. Trucking companies have sometimes independent contractors. Uber and Lyft would like to call all of their people working for them independent contractors. DoorDash, those kinds of places have made this come kind of to the forefront as far as at least here at the department and at the governor's office and even in the legislature. So independent contractors are statutory employees of the employer unless, I'm sorry, employer they are working for, unless they meet all elements of a 9-point test under section 102.07, paren A, paren B, Wisconsin statutes. So that 9-point test is pretty comprehensive. To be an independent contractor, basically you have to bring all your own tools and all your own equipment to the job site. You have to get the job on a bid basis, not just, hey, I showed up, my Uncle Joe told me to show up today and put me to work on the roof and told me what to do and provided all the nails and the nail gun. And yeah, I did. I brought my own hammer, but I realized I didn't need it, kind of thing. That would not be an independent contractor. So we look at that 9-point test, and I have held a number of hearings over the years on this particular issue, 1 or 2 times in all of that time in the last 27 years. Have I found that somebody is actually an independent contractor. Generally, they don't have their own office that they're maintaining. They don't have their own FEIN. They are not filing, I think it's called a Schedule C, taxes with the IRS, that somehow they're getting a 1099, so they are an independent contractor. So most people will be considered to be employees of the employer, and sometimes we'll have to have a hearing on that particular issue. So the 2 basic requirements for a compensable workers' compensation injury are, and I sorry I have to read this, but I sometimes mix it up with my former home state of Michigan, and I'll use the wrong terminology, so I don't want to do that for you. At the time of injury, the employee is performing services growing out of and incidental to their employment. And 2, the injury arose from the employment. So this is a causation requirement, and there must be a causal connection between the injury and the workplace or the work activities. And again, you will find that under section 102.03, and we give you the rest of the details there is to the specific section that you will find that in. Now, for employees, we do have some reporting requirements. The statute, says that the employee should give notice to their employer within 30 days of any injury. The notice must be given within 2 years of the date of injury or from the date the employee knew of the nature of the disability and its relation to the employment. And this includes occupational disease. So sometimes what happens with respect to this 2-year rule is that somebody worked with asbestos, say, in 1966. And at that time, there was not as much known about asbestos and the cancer-causing agents that come from asbestos exposure. So what could happen is in 2006, Bill, let's use that for instance, Bill goes to the doctor and he's been having trouble breathing and he's really feeling poorly. And the doctor says, oh my goodness, you have a condition called mesothelioma or asbestosis. That's a problem. Where do you think you had exposure to asbestos at? Lots of questions are asked. Well, then Bill starts to think, well, I was a painter, for instance, and when I was a painter back in 1966, we were taking out asbestos or putting in asbestos and this, that, or the other thing. And so the doctor says, well, gee, I think that might have been the cause of your problem here, the cause of this condition. So what the employee can do is file an application for hearing with the department, or if they know who their employer was at the time and they know who the insurance carrier was at the time, they can make a claim directly with the employer or the carrier. I guarantee you probably the employer is now out of business because that was a long time ago, a good 40 years or whatever. And so the insurance carrier hopefully is not out of business, and the insurance carrier may well be liable for the injuries sustained and the ongoing treatment that Bill needs. So that is a good example of why the injury would not have been reported within 2 years of the date of injury, but it would be reported within 2 years from the date the employee knew of the nature of the disability. Okay. So the other thing here is a constructive notice to the employer satisfies both the 30-day and 2-year notice requirements. And constructive notice usually means that the employee told their supervisor, they told someone in HR, they might have told the head of the company, that type of thing. I have never seen a workers' compensation claim denied because notice was not given within 30 days or 2 years. I suppose we learn something new every day here at the department, so that could happen. Potentially in the future, that could happen. Okay, so let's go on and talk about reporting requirements for employees. For traumatic injuries, which we talked about a little bit about before, that's something that just sort of happens out of the blue. It's a one-time event. A hearing application must be filed within 6 years after the date of injury or the date of death or the date of last payment of compensation, whichever is later. And this applies to injuries on or after March 2nd of 2016. So before March 2nd, of 2016, everyone had a 12-year statute of limitations to file their workers' compensation claim for traumatic injuries. All right, so we go on and we talk about occupational disease, which sometimes is a more severe situation, a more long-standing problem or a bigger problem that people would have as far as injuries go. And in the case of an occupational disease, the application needs to be filed no later than 12 years after all of those things I just talked about, either the date of injury, the date of death, or the last payment of compensation. If the application is filed beyond the 12 years, okay, then benefits are still paid from the Work Injury Supplemental Benefit Fund, which we here at the department refer to as WISBF, WISBF. So we see a number of those claims made every year also because people have missed the 12-year statute of limitations. Maybe they haven't had benefits in a long time. Insurance carriers do not call up injured workers and tell them, hey, your statute of limitations is about to expire. They just let it run. Sometimes people are on top of it. Maybe they have an attorney that represented them or whatever, and they then file a new hearing application for an order for prospective medical treatment and we would call that ongoing benefits, basically. So those kinds of things do happen. So let's talk about reporting requirements for employers. Insured employers must report all work-related fatalities within 24 hours to the department and their insurance carrier. Generally, it's the insurance carrier nowadays who reports fatalities to the department, but on occasion, we do have an employer who does it. Either way, we want it done within 24 hours so that we know what is going on and that we're aware of any fatalities. It's always unfortunate when that happens, but we reach out to the family, extending our condolences, and then we try to get whatever information we can to help the insurance carrier ensure prompt payment of benefits if benefits are due. Insured employers must report all compensable, sorry, I'm getting a little, I guess, tired here today, injuries to the insurance carrier within 7 days on a WKC 12 form, which is also called a first report of injury. And then an employer's insurance carrier has primary liability for unpaid medical treatment. So those are the three things that you need to keep an eye on. First of all, the first two are the important ones. If somebody dies at your place of employment or while working for you, make sure you get it reported. And all compensable injuries should be reported to the insurance carrier within 7 days. If it's a medical only, which means only medical bills are paid, there is no lost time, there is no permanent disability, the insurance carrier will not report that to the department. But if it is a lost time claim where temporary total disability is due and payable, or there's 3 weeks of permanent partial disability, or if it's an eye injury, which this is a very unique one, if it's an eye injury that requires, I think, more than 3 treatments off-site of the employer, then that is to be reported to us too. So your insurance carriers know what they're doing, and so report your injuries to them and then let them flesh out whether or not it's a legit injury, whether or not it needs to be paid. On occasion, we have an employer who decides they're not going to report the injury to the insurance carrier. They may drop the injured worker off at the urgent care and say, hey, don't tell them you're employed by me, but I will go ahead and make payment for the medical bills. That's all fine and good. Well, it's not fine and good, but it seems fine and good until the person needs surgery or until there's an MRI bill or something like that. I think some employers sometimes think that if they just drop the person off at urgent care, it'll be like a $300 bill and there'll be no more treatment. There will be no more billings. That's not true. We've had a ton of employers over the years who do something like this, and then they report it to their insurance company because the person has lost time. The insurance company gets dinged for a delay in payment and they blame it back on the employer, and then the employer tries to blame the employee, and it just doesn't work like that. So I have an excellent story about this. There was an employer who employed their son. The son got injured. The employer refused to report the injury timely. Eventually, it did get reported. The insurance carrier got dinged for the delay. The insurance carrier pointed the finger at the employer. The employer sent the bill to the son and said, you pay it because you got injured. And then there was another delay in payment that was issued. I issued an order regarding it. And finally, I talked to the carrier, and the carrier's like, well, the employer told his kid to pay it. And so I had to have a call with the employer who was not super happy with me when I said, that's your responsibility because you're an employer covered by workers' compensation here in Wisconsin, and you need to know the rules of the road. So I'm assuming that particular individual did pay the penalty, because we do require as the employer that you provide us with a copy of the canceled check that shows that you did in fact pay it. So I'll tell you, there's never a dull moment here in workers' compensation. Okay, so as an employer, some procedures or policies that you should have in place is, first of all, please encourage people to report their injuries. Do not discourage reporting minor injuries. You may not need to even send it over to your insurance carrier because there's no treatment that's been performed or undertaken. There's no loss of time, but you as an HR person or you as the owner of the company or whatever role you play, if you're your workers' compensation liaison, I would make note of the injury on my calendar. If it's a big paper cut, I would make note of it because sometimes what happens is people, you know, develop other conditions. They could develop an infection, which then results in gangrene, which then results in the amputation of a finger or two. And then all of a sudden, your insurance carrier is saying, why in the heck didn't you tell me about this? You know, what's going on here? And you can say, well, it was a minor injury, you know, back on January 1st. I checked in periodically to see how things were going. Nothing happened. But then Bill took off for a vacation, went camping out in the woods, you know, and when he came back, it was hugely infected. But I didn't necessarily know that it was work related at that point in time, kind of thing. So those are things that you should do is keep track, report, tell people to report, have a mechanism for reporting, have a form that people can fill out and sign, and make sure that the person that's receiving the form has some training on how to accept the form. You know, it's not just, hey, throw it on my desk. We have a process. I'm going to file the form here. I'm going to make it into a PDF and send it on to whomever. And if an investigation needs to be done, you want the person receiving the accident form to know what steps need to be taken next. And that's just a standard practice, I know, for a lot of employers. All right. So steps that you should take, whomever your internal representative is, that person who's supposed to be investigating, make sure that they get the details of the accident or the injuries, the treatment that's being offered. Talk to coworkers, see if anybody should be signing, you know, a statement as to what happened. Make sure that the worker signs the injury report and is provided with a copy of it. You know, everybody walks around with a camera basically in their back pocket nowadays, or in your purse or wherever that you keep your phone. But make sure that some pictures are taken of the accident site before it is cleaned up or altered. That is highly important. Sometimes I've had some really good photos over the years when somebody says, well, this and this and this happened. And I go to look at the photo and I say, but I don't see that. You know, and sometimes the person misremembers that's testifying. They remembered that stuff, you know, that cord was sitting there 3 months ago, not when they actually got injured. So the brain is a tricky thing, and sometimes it does funny things, you know, for us. It may not see something exactly the way it was, but it remembers something totally different. So make sure that that is documented. Again, you can contact any witnesses, get a signed statement from them, and then make sure that the results of the investigation are forwarded on not only internally to you, to whomever is handling the workers' compensation claim, but you also want to follow up with the insurance carrier with that information. They will want to know that. They will determine whether they think it is great information or not. And maybe you and they will disagree, but it's okay. That's okay too. It's better to have too much information than too little information when it comes to a work injury. So I kind of got ahead of myself. Make sure you report your injury to the insurance carrier, or if you're a self-insured employer and you have a third-party administrator handling your claims, make sure that that information is all passed on. They will determine whether it needs to be reported to the state of Wisconsin. And I talked a minute ago about a little bit of some of these penalties. The failure to report an injury timely to the insurance carrier, who then fails to report it timely to the department, can result in a couple different things. There can be the delay in payment, which is a 10% increased compensation for the compensation that was delayed. Or there is what we call bad faith. Nobody wants to hear that phrase ever. That's up to 200% of the compensation delayed. And that can be up to $30,000 per occurrence. And we put that into effect in April of 2006. It used to be $15,000 back in the day. And then they boosted it up. I have never actually, well, that's not true. I've had a couple of claims where or a couple of hearings where bad faith was the primary issue, and I did award $30,000. Well, the one I issued more than that, maybe $60,000, because it was multiple occurrences of bad faith. But bad faith is something no insurance carrier wants to hear, and you, as the employer, do not want to hear that phrase pointed at you either. So do the reporting, make sure your insurance carrier knows. They will then take it from there for you. So now, some of the things that you can do after you've given the notice of injury, if you have doubts about the injury, the mechanism of injury, some inconsistent statements that were made, talk to your insurance adjuster that is handling the claim. They will talk to you about this. They will take notes, they will make notes, they will follow up on it if they think there is something that is needed to be done. All right. If you have any medical records from your injured worker, all right, so they go, say, to the urgent care, they bring back a light duty work slip, make sure that you forward that on, a copy of that to the insurance carrier also. We also require that the employer provide the insurance carrier with wage information. And generally, the calculation is looking at the last 52 weeks of work for the employer. If the department doesn't have enough information, once the average weekly wage is submitted by the carrier to the department, if we don't have enough information to make sure that this is correct, then we will reach out to the carrier, who then may reach out to you and say, hey, I need some additional spreadsheets on this person's wages over the last 52 weeks. Also, send the carrier any additional information that you have. If your company has a sickness and accident plan, or benefits have been paid, short-term disability type of things, or long-term disability, send that along to the carrier because they need to know that. Also, any medical documents that you have, any letters that you may draft offering the injured worker light duty work, you should provide that to the insurance carrier as well as to the employee. One of my bigger concerns nowadays is with our technology system, and a lot of employers are using texting as a way of communicating with their employees. That's all fine and good, but it's not as good as a letter. It's not as good as a letter to an individual that spells out what job you are offering them at light duty, and what the hours of employment are, what the shift is, what the pay is, and what they're going to be doing. Texting is potentially the bane of my personal existence because I like to write things out in full, and I'm not always good at the abbreviations. And a lot of people talk in abbreviations nowadays. So should a case go to hearing and all you have are texting, snippets, so to speak, that's not really in context, and I'm not even sure it's from who you say it's from, because generally, at the top of your screen is who the person you're communicating with, but it doesn't say that throughout the communication. So it can be difficult. You may need some extra testimony coming in that, yes, I'm Kathy, the supervisor, and yes, those are the texts I sent to my employee. So it's just something to think about. I think a written offer of light duty work is the way to go. On your company letterhead is even better, and signed by somebody that's in an official capacity to sign it. So the next thing that you should do as the employer is to provide accurate information to the employee. Claims not reported within 24 hours will not be paid. That is not true. So claims, if you want them reported within 24 hours, that's great. But the statute doesn't say that. So claims reported within 24 hours will be paid. Claims that are reported a couple weeks later might also be paid, just depending on the circumstances. We have a lot of employees that I've talked to over the years, a lot of stalwart people out there in Wisconsin. We are, we're, in my opinion, we're Wisconsin are Midwest nice to pretty much everybody, but we also are the type of people, myself included, that I will drag myself into work when I am sick if needed, or if I've hurt my back or whatever. And I do have a prior back injury from a couple of different places I worked over the years from a long time ago. And when it flares up, I still go to work. And at some point, though, for a lot of people, they go home, they think they tweaked their back. They go home, they sleep on it. It really stiffens up when you sleep on it. They get up the next day and they realize that they hurt it a lot more severely than what they thought at first. And so it may be a couple of days before they report it. They might take a couple of sick days or a couple of vacation days because, again, we Wisconsinites and from Michigan too, but we Michiganders are tough people. We go to work no matter what. But then at some point, people realize, gosh, I can't do this anymore because I can't go back and do the type of work that I was doing till I seek medical treatment, till I get a cortisone injection, till I've had a little bit of rest. So please don't tell people that if you fail to report it in 24 hours, you're not getting paid, because that's not true. And this is up here because people do say that. It's not you saying it, but people do say it. You cannot require the employee to seek medical treatment only from the plant doctor. In Wisconsin, the employee has choice of practitioners. You have choice of up to 2 practitioners. And then if there are any referrals off of either one of those 2 practitioners, those are covered as though they were from the original practitioner. So, and I don't know how many companies actually still have plant doctors, to be honest with you. It was a lot more frequent that I would see that, or I would see, I guess, yeah, I would see that with more frequency, sorry, in the past, maybe 30, 40 years ago, we would see that quite frequently. All right. And a person's job should not be in jeopardy if they are out of work due to an injury. So sometimes people will be told that, well, if you don't come back to work right now, then you're going to be fired. We're going to let you go. Well, you as the employer have that prerogative. I've had employers call me and talk to me about this over the years. And I always tell them, is that really the best route to take? Because we'll talk about this in a minute, but if you terminate someone because they had a work injury and they're not able to come to work, when they get better and they don't have a job with you anymore, then they may have a claim against you for a penalty, which is up to 1 year's worth of actual wages. And we call that unreasonable refusal to rehire under section 102.35. And I've had a whole bunch of those claims over the years. And I would say 95% of those, the injured worker received their full wages for 1 year because they were terminated because they had a work injury and someone was hired to replace them right away. So you may need somebody to replace the individual, that is true, but then you need to talk to your insurance carrier about what you're going to do. Just firing somebody is probably not the best way to go. And don't make up a bunch of stuff about the individual, that they've always been a bad worker if you haven't documented it previously. And I know that none of the people on this call today are those people, but I have had a number of those hearings over the years too, where, Kathy is a really bad employee. We've been looking to get rid of her all the way along. It just happened she had this work injury. We were working on getting rid of her or terminating her just before she had the work injury. And then when you ask, well, where's all the documentation? Oh, we don't document anything like that. Well, that, in my opinion, makes you maybe not very credible. Okay, so the 4th step you should be taking as an employer is provide work within the employee's restrictions. Now, sometimes when the employee goes to see a physician, the physician will say, hey, I don't think you can go back and do this heavy work that you were doing that required a lot of bending, twisting, lifting, and turning. But what I think you can do is the following. You can have a sit-stand option. You can sit for up to 6 hours a day. You need to elevate your leg, blah, 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 blah. There's lots of opportunities out there for doctors to limit what somebody is going to be able to do for the next, say, 6 weeks, 8 weeks, whatever it is, or even a couple of weeks sometimes. So if you are one of those employers who have an employee who comes with a restriction slip, make sure that the work that you are providing is within those restrictions. I've often had people testify that I went back to work and yeah, the employer was great until my supervisor got mad at me because I wasn't pulling my fair share for the week and told me I had to do X, Y, and Z, and I told him or her that I can't do that. And they said they didn't care. They were going to write me up. Well, again, we're a stalwart community, and we do try to do what we're told, and we're, for the most part, rule followers. So people try to do the extra work that they are now being told they have to do, and oftentimes it just results in an aggravation of the already existing condition, which doesn't help anybody. However, there are studies out there that show that work provided within the employee's restrictions decreases the period of disability that they are basically off of work, and it provides intangible benefits to the employee. It gets them back to work. It gets them back in the workplace with their colleagues and their friends. And those kinds of things are very helpful for people in their recovery. The other thing is, if the doctor's note is kind of like you don't even know what it basically is saying, it's okay to ask the injured worker to get more information from their doctor as to what the actual work restrictions are. If it's just, you know, um, no walking more than 8 hours, and the person never did any walking for 8 hours, then I think I would want some more information from the doctor, because maybe the doctor didn't really understand what your employee does, or maybe the doctor was very busy at the urgent care or at the emergency room and just wasn't paying attention. I know that would probably shock you, but I've seen I've seen things come in from emergency rooms, urgent cares, even from physicians, and the description of what is going on there, even of the injured person, the patient, is incorrect. So sometimes medical records are not always accurate. And if that is determined to be the case, then somebody needs to follow up with the physician. You, as the employer, could also follow up with the physician. You have the right to do that to clarify those work restrictions. The insurance carrier can follow up with the physician also. So, all right. And then do not, see that's bolded, require employees to perform work outside of their restrictions. Again, we just talked about why that is a bad idea, and I really cannot stress that enough. So then we'll move on to what benefits are payable. We've talked a little bit about this before: temporary total or temporary partial disability during the healing period. Those are wage loss benefits. Those are for the actual wages that are lost. And those are calculated, at least TTD, is calculated at 2/3 of the person's average weekly wage. Temporary partial disability benefits is calculated based upon how much time the person worked and what they earned, basically what they earned during their healing period when they were provided with light duty work versus what their temporary total disability should have been. And if you don't know how to calculate that, which you probably don't because it's not the easiest thing to do, the insurance carrier should be able to do that, but they are going to need the wages earned during those weeks of light duty work from you, the employer, in order to calculate it. And if all else fails, you can contact the department and the department can calculate it for you, of course, based on the actual wages for the period of time that the person worked at a light duty position. All right. One of the other things that is payable is vocational rehabilitation benefits. That's basically retraining, whether it's through the Division of Vocational Rehabilitation, DVR, that's one of the agencies here with the state, or if it's through a private vocational rehabilitation counselor, which there are a number of those here in Wisconsin, and most of them are on our list here at the state, and we can refer people out to those individuals. Then we have permanent partial disability, which we also refer to as PPD, scheduled or unscheduled. Scheduled is anything from the arms, the shoulders, all of the way down to the fingertips, also from the hips all the way down to the tips of the toes. Unscheduled injuries are head injuries, back injuries, mental injuries. And permanent partial disability is a benefit that results from a permanent impairment that occurs as a result of the work injury, but does not leave you in a state where you cannot ever work again. Permanent total disability benefits are just that. You are totally disabled. There's nothing that you can do within your education, training, etc. You're not getting vocational rehabilitation training. This includes, there's a couple different kinds of permanent total disability benefits. One is statutory. The statutory one is the loss of an arm and a leg, loss of both arms, loss of both legs, loss of both eyes. Okay, so that just means that you're permanently and totally disabled under the law, whether you can return to a job or not. The other type of permanent and totally disability benefits, sorry, I'm mangling my words here today, is under the odd lot doctrine, which we call loss of earning capacity. And this means that a vocational expert has determined that based upon your age, education, training, experience, and there's a few other things I don't remember right off the top of my head, I guess, that you are unable to go back and do the type of work that you were doing and pretty much any other type of work. So sometimes what happens, I haven't seen it as much lately, but a number of years ago when I started, I had a lot of men in their 50s and 60s who had worked heavy construction jobs their entire lives. Some of them couldn't read, some of them couldn't write, some of them couldn't read or write, basically. And one might ask how they got the jobs. Well, times were different then. You didn't usually fill an application out, online. You might go in. One gentleman testified he went in and got the application and he said, "Hey, I forgot my reading glasses. Is it okay if I take it home, fill it out, and bring it back?" And the employer was like, "Sure, that's totally fine. Go ahead and do that." Took it home, had his wife take care of it. So those folks probably would fit within the permanent and total disability category because sending them back to school for retraining may have been just too much for them in the long run. Now, a lot of people like to say they are lifelong learners. I get that, but it's very hard for people that have no ability to read or write, or very, very limited ability to read and write, to go back to school in their late 50s, early 60s, whatever it is, get remediation, schooling to learn how to do those things, and then move on into a career that's different from what they've done their entire lives. So that's my side story on that. Medical expenses are covered, and death benefits are also a part of workers' compensation claims. We have some special types of claims that can be made, and these are basically penalty claims. A safety violation by the employer, a safety violation by an employee, a violation of the employer's drug or alcohol policy, and the unreasonable refusal to rehire. Oh, one of the things about the unreasonable refusal to rehire, that particular claim is made directly against the employer. That is not insurable under your workers' compensation insurance policy. So we try a lot of those because employers are not necessarily willing to pony up $50,000, $60,000, whatever the injured worker's annual actual wage was. So we'll talk a little bit about these. The safety violation, if the employer fails to comply with any state statute or administrative rule in the Wisconsin Administrative Code, and if the violation is a substantial factor in causing a compensable injury, then a 15% penalty must be paid by the employer to the employee. That 15% is it's on all the benefits paid, basically. So the employer has primary liability for the increased compensation, but an insurance carrier has secondary liability. So if the employer goes bankrupt or ceases maintaining its business, and there's still a safety violation being claimed out there, then the insurance carrier has to step up and make those payments on behalf of their former insured. You would be surprised at the number of employers who maybe change names or change kind of businesses a little bit. Maybe they branch off and do something else and they change their name, or they say that they're no longer a business, that's registered with the Department of Financial Institutions here in Wisconsin. And then, they move on to do. I'm sorry, my computer kicked me out of the meeting. I apologize. I was worried about doing this from home because I thought that would happen. And I'm at the office and it happened. So my apologies, and I'll just move on. I was kind of talking about employers who change names or move on to some other type of business. You would be surprised at the number of insurance carriers who have a trail to the employer because they're going to make sure the employer makes those safety violation penalties that is paid by them. And then in some instances, either again, I apologize. This is the second time that it's booted me out. So maybe it doesn't like how I'm talking. I'll try something different here. The Department of Safety and Professional Services also has a division called the Safety in Buildings, and they may do also an investigation if there's an allegation of a safety violation. Okay, and so we'll move on. A finding of liability may be based on either a violation of the safety rules, either rules that you as the employer have, or a violation of the Safe Place statute, which is under chapter, I think it's.
Kathy, you'll just need to reshare your slides.
Oh,
Didn't
I'm
mean to
sorry.
interrupt you.
Yep,
Yeah.
no, I'm sorry. Thank you for reminding me because I think I might have mentioned I really needed my kids here
Yep,
to
there
be
we
with
go.
me. Sorry.
No worries.
Good Lord, technology, so good, but so not good, right? If we were in person, you'd still be seeing me move my lips. You might not hear me, but I'd still be talking. Okay, so we're talking about either an employer safety rule was violated or the Safe Place statute was violated. And I believe the Safe Place statute is chapter 101.111, I think. I haven't used it in a while, so I'm not exactly positive, but it's close to that. The employer has the burden of enforcing compliance with all safety rules and the Safe Place statute, and the employee must then prove that the employer had actual constructive notice of an unsafe equipment, condition, or practice. So that's what the employee would allege is one of those things. And if it goes to a hearing, then the burden is on the employee to prove that there was a safety violation, but then we would want also testimony from the employer to talk about what happened here, and bring in, safety logs or work logs or the safety handbook, that kind of thing. So the employer may not be able to raise the defense that the injury was not compensable. So sometimes what happens is the insurance carrier goes ahead and pays the claim, pays for the work injury. Then a safety violation is brought a little while later, and the employer wants to come back and say, oh, that injury was not compensable. Well, if the insurance carrier who acts on your behalf, as on behalf of the employer, I mean, they're your representative, they're your agent, basically. If they say it's work related, then you're stuck with their finding that it's work related. So the employer should consider retaining an attorney. And I would suggest that you get somebody who knows something about workers' compensation law, because sometimes when you hire your corporate counsel, and there's nothing wrong with your corporate counsel, I'm not saying that. But as a lawyer myself, I don't try to practice in areas that I don't have any actual knowledge in. And oftentimes corporate counsel or, a friend of a friend of a friend doesn't really understand workers' comp. And when they come in and they start making arguments, one has to say to them, yeah, that's really not how this works. And so it often is a very dissatisfying experience for the employer and for their attorney, type of situation. So The initial investigation following the injury is crucial. We talked about that before. Make sure you investigate. You want to show that there was no safety violation that occurred. So then we have a section of the statute, and this is 102.58. And this is if the employee violates a safety rule or the safe place statute. Death benefits or disability benefits can be decreased up to 15%, or I'm sorry, by 15%, up to a maximum of $15,000 if an injury is caused by the employee's failure to use a safety device that was adequately maintained and its use was reasonably enforced by the employer. So if somebody removes a guard on a machine, though, that's a potential safety violation by the employee. I don't think I mentioned that about the other section either. 102.57 is still the maximum that they can get from the employer is $15,000 or 15% up to the $15,000. So, again, look at these things, investigate them, make sure that there wasn't any violations going on or any issues going on, and make sure you document that with your insurance carrier. Even though you're liable for it, at least as long as you're still salient and in business, you still should let the insurance carrier know so they are aware of what's going on. Then we have some specific things that came about in March of 2016 regarding the violation of an employer's drug or alcohol policy. This, in essence, brought us into, I think, the 21st century kind of on what happens in the workplace, because I'm sure there is more drug and alcohol usage than any of us would like or appreciate. And this goes on to talk about how if an employee violates the employer's policy concerning employee drug or alcohol use and is injured, and if that violation is causal to the employee's injury, then no compensation or death benefits are payable to the employee or his or her dependent. All right. And again, this applies to injuries on or after March 2nd of 2016. Now, there is a caveat here. See that phrase that says is causal to the employee's injury. So I always like to give this example. So we've got Joe and Bob. And Joe is drunker than a skunk, and he's walking along the aisle, kind of minding his own business, trying to get back to his workstation. And then his coworker comes driving the forklift wildly. He kind of likes to scare people a little bit, make them jump on their feet a little bit kind of thing. And he ends up running in to our guy that's walking along, runs him over, serious injuries. You take him, you call the ambulance, you go through the protocols, they take him to the emergency room, a blood alcohol test is done, and it's determined that he was drunk. He was drunk. Okay. But I would see that the issue here would be this, that the violation, his being drunk, isn't what got him run over, right? It's not what caused his injuries. It was his coworker's negligence or intentional harmful act, however you want to look at that, by running him over with the forklift. So as a result, the injured worker is not going to be without benefits. Yes, he violated the alcohol and drug policy, but the violation was not causal to his work injury. So, and we have a number of those that come through every year where the employer and insurance carrier are asking about the violation of the drug and alcohol policy. And mind you, the drug and alcohol policy also needs to be enforced. It can't be something that after the injury you drug out of your desk drawer with 3 inches of dust on it and you say, hey, we've been enforcing this all these years, when in fact it appears that you have not. Okay. So compensation for temporary disability may be denied when the employee's employment was suspended or terminated due to the employee's violation of the employer's policy concerning employee drug use during the period when the employee could return to restricted work during the healing period. Long and short of that is if the person is released after an injury to return to work at light duty or restricted work, and they violate the employer's drug policy. It gets complicated. It seems like it's not, but it is. Violates the employer's drug policy, then temporary total disability benefits or temporary partial disability benefits can be denied by the insurance carrier. This came in response to, I believe it was I want to say it was the Breakbush decision. But you can go out to section 102.439C and take a look at this and read it for yourself. I think there's probably a footnote that's attached to this. All right, moving right along. Unreasonable refusal to rehire, which we talked about that a couple of minutes ago, that is a penalty claim solely against the employer. It is not insurable. And the definition basically is an employer who, without reasonable cause, refuses to rehire an employee after the employee has sustained a work injury, then that employee may be entitled to up to 1 year of lost wages. And that's actual wages. That's not, it's actual wages. So that's not the TTD rate, which is 2/3 of your average weekly wage. It's the total amount of wages. So, okay. And the employer may not be insured or indemnified against this liability for lost wages. I guarantee you, your insurance carrier will not offer you a policy for this particular penalty claim. Pardon me, I need to take just a brief sip of water. Okay, so the elements of the unreasonable refusal to rehire. 1, the worker had to be an employee of the employer at the time of injury. The injury must have been compensable, and the employer refused to rehire the employee or rehires and then fires the injured employee without reasonable cause. These are all factual elements that if you go to a hearing on it, the judge is going to want to hear a whole heck of a lot about your practices in hiring and firing people. And, why did you need to let this person go? Was there a business reason? There are a few reasons that are considered appropriate to let someone go or to terminate them, but it becomes a lot more difficult when the person has had a work injury and it's not clear that the injured worker was on the track to being let go before the work injury. These are things definitely to talk to your attorney about. Suitable employment must be available to the employee within their physical and mental limitations. The employer should consider retaining an attorney. Again, I can't say that strongly enough to you. I've had a couple people represent themselves over the years, and by the end of the hearing, I'm sure they wish they had spent the money on a lawyer because it's complicated. It's not as easy as what people think it is to come in and represent yourself. And be sure to document. Have, whatever HR protocols that you use to determine whether an employee should be subject to discipline or should be terminated or whatever, make sure that you have that documentation in order when you let someone go after they've had a work injury. So, all right, so we are getting down to kind of the last of the slides here, and I'll try to kind of move along because I know everybody has things to do today. A hearing will occur after an application for hearing has been filed by the injured worker, all right, and an answer has been filed by the insurance carrier and or employer. Effective January 1st of 2026, all of the adjudicatory functions were returned to the Workers' Compensation Division. Effective, I believe, January 16th, I think, of 2016, we had a bifurcation. Most of our administrative law judges who held hearings moved over to the Division of Hearings and Appeals, and they parted ways with the Workers' Compensation Division. About a little over a month ago, they returned to us after being gone for 10 years. And we're still in the process of hammering some things out, but things are going well so far. All hearings in litigated workers' compensation cases are held by an administrative law judge who is a lawyer licensed in Wisconsin and is also employed by the Workers' Compensation Division. At the hearings, parties are generally represented by attorneys. The judge will determine what the conceded and disputed issues are, and will discuss those with the parties. Settlement discussions may take place before the hearing or sometimes during the hearing. People want to take a little break because testimony isn't going as well as they thought it would go for their case. And so they may say, hey, judge, I want to take a couple of minutes. I want to talk to the other side. And I'm always surprised by the number of people who come back and say, yeah, we've come up with a number that we're willing to settle this case on. Testimony is taken under oath by a court reporter. It is recorded. And workers' compensation hearings are very informal proceedings. Well, they're formal proceedings, but they're kind of informal. We don't hold them at a courthouse. We try to find rooms throughout the state, whether it's at a state office building or a municipal building or a library, or goodness gracious, up in Chautauqua, I think we used to go to like their community center and hold hearings. We've been at the Armory in Janesville over the years. We've been at libraries. I had to arm wrestle a hearing room at a library one time from the Cub Scouts. That was not good. That made me look really bad, but oh well, these things happen. And there's no jury here. There's just the judge. The judge will go back to their office after the hearing and make a decision. We have 90 days to issue the orders. Testimony is taken, and we don't take extraneous testimony. I mean, or repetitive testimony. If 5 people want to testify all to the same thing, we'll just go with one person testifying. That's good enough. Usually they're scheduled, the hearings, anywhere between 2 and 4 hours. Sometimes you have to have a continued hearing, which means you'll come back another day at some point in the future to resume trying the case and hopefully finish it up that day. So what happens at the hearing, kind of continued here, there is no presumption of eligibility of benefits. This is up to the judge to decide once proof has been put into the record. In most cases, the injured worker has the burden of proof, except for refusal to rehire. Then the burden of proof shifts to the employer to show that they didn't unreasonably refuse to rehire the injured worker. Okay. Medical evidence is needed to support the claim. You need something from the physician if it is a claim where medical is in dispute. If it's an employer-employee relationship, then no, at that time you do not need medical support for the claim. Generally, what happens is the insurance carrier gets a medical report from a doctor of its choosing called an independent medical evaluator or examiner. And then the injured worker gets medical support from their doctor, who is usually their treating physician or somebody that they've been referred to by their treating physician. There are filing deadlines for medical reports and reports regarding medical bills and vocational reports. Those deadlines are set in statute, but there are options. If you have good cause for why things didn't get filed timely, then you can bring that to the judge's attention, and the judge has a couple of options on how to deal with that. Orders are generally issued within 90 days after the hearing is done or the record closes. Sometimes as an ALJ, I will keep the record open for 30 or 60 days because the parties are promising me that they have some additional information that I just have to see. So I will leave the case open for a period of time. Once I get that information, I close the record and then issue my decision. Appeals are taken to the Labor Industry Review Commission, which is the appellate body that is over the Workers' Compensation Division. They are not appealed directly to the circuit court like some states are, or to the Court of Appeals, or to the Supreme Court of Wisconsin. There are other states where that does happen directly, but not here in Wisconsin, it doesn't. So, and that is the end of my presentation. Let me go out and look. And I am sorry that I got booted out a couple of times. Well, it looks like there's not a lot for me to answer, but if anybody has anything, please drop it in the chat. I can put in the chat, though, my email address if you ever have any questions. you can email me, or you can call me. I'll put my number in there too. If I can spell Wisconsin, that would be good. And then I'm also, here's my direct line. Call me if you have any questions or you need some information. I'm happy to talk with you.
Thank you, Kathy. And anyone, if you have questions for Kathy or Brian, feel free to share them in the chat.
I just wanted to mention, I'll put my email address and phone number in the chat as well for individuals.
Doesn't look like there's any questions, so it looks like we are going to wrap this session up. Thank you all once again for joining us. Thank you, Kathy. Thank you, Brian, for presenting, and we will hopefully see you either on Friday or in a couple of weeks for our next couple of sessions. Thanks, everyone.